Thanks to America and to the detriment of India and the world, the end of the World Trade Organization appellate body is nigh. This de facto Supreme Court of International Trade will breathe its last breath on December 10, 2019. Why should its demise matter? How should its judges interpret disputed terms in a WTO treaty? These two seemingly unrelated questions are directly linked. Unless the United States stops blocking the appointment of new appellate body judges to replace those whose terms are expiring, on December 11th, the court will lack the minimum 3 judges required to hear cases. Simply put, appellate body jurisprudence catalyzes positive synergies for India's legal, business, and policy communities. Those synergies are thanks to the Dispute Settlement Understanding, one of the Uruguay Round treaties, which creates a 3-step game on a level playing field to resolve disputes: consultation, adjudication, and compliance. The common metaphor for the DSU as the WTO crown jewel is apt. One of those crown jewels is the appellate body. India is another jewel in the WTO's DSU crown. India is rather a role model for developing countries in DSU adjudication. In 2001, India scored a knockout victory in the bed linen case it brought against the European Union. Bed linen set an informal precedent that America despised. It is the job of the appellate body to harmonize jurisprudence, equal justice under law for all WTO members. Surely, it's unjust to allow America to use zeroing against Indian or any other member's exports when it's illegal for the European Union to do so. Yet the United States was hooked on zeroing, seeing zeroing as an indispensable remedy against unfair trade. It's not. Nobody else zeroed in anti-dumping cases after bed linen. Yet America fought on alone. The United States Department of Commerce finally ended zeroing, not in deference to the appellate body, in all but targeted dumping cases. Despite over a dozen losses, America's WTO litigation record is excellent. America wins 87% of the cases it files as complainant. America loses 75% of the cases that are filed against it as respondent. Both figures are better than average for the WTO membership. So the real underlying reason that America is choking the WTO Supreme Court of new judges is that the U.S. objects to how the old ones decided cases. The Obama and Trump administrations demand that any new judge on the appellate body stick to a strict constructionist approach to legal interpretation. India and the other WTO members still think that judges, ought to judge. They appreciate that the DSU mandate to the appellate body, which is to adhere to decision-making pursuant to Articles 31 and 32 of the 1969 Vienna Convention on the Law of Treaties, is a liberating mandate, not a constraining mandate. Those articles allow for the use of textual, contextual, or pragmatic methodologies for interpreting disputed terms in a trade treaty. With no appellate body to which to appeal from panels, India and other WTO members can invoke DSU Article 25. That's bilateral arbitration. That's a suboptimal short-run solution. India's best long-run option is to hold true to what it and the rest of the WTO members know is right. America's effort to export to the appellate body its anomalous interpretative ideology is parochial in theory and ruinous in practice.